very honored to be able to have Greg Farrell interview Assistant Attorney General Leslie Caldwell and talk to you a little bit about enforcement policy and where things are going. So please.
Thank you very much. Thank you all for coming. It is indeed my pleasure to have the Assistant Attorney General in charge of the Criminal Division, Leslie Caldwell, here today. And since we only have a short period of time, I will compress her very impressive biography and talk briefly about how she started in Brooklyn and was a violent crime drug prosecutor, eventually moving to securities fraud, white-collar crime, moved out to San Francisco during the dot-com boom and built a major case against McKesson involving securities fraud before she was selected to be the first head of the Enron task force. After leaving or on her way out of the Enron task force, the Justice Department asked her to do a white paper to analyze the fraud division, the fraud section of the DOJ, and recommend improvements for it. And she was called upon 3 years ago actually, and it took 9 months to get her confirmed. She was named to be the head of the criminal division. So it's our pleasure to have Leslie Caldwell here today.
Thank you, Greg.
So Leslie, especially given the audience that we have here in the corporate background, I've followed a lot of DOJ settlements in recent years, particularly with large banks and corporations. And there came a time, at least up until when you arrived 2 years ago, where I heard a lot of complaints from, including people in this room, about proportionality of settlements and fines, about rationality behind it. In other words, there was a time when one bank committed a certain set of international sanctions violations and money laundering and got fined almost $2 billion. And then later, a different bank seemed to do something in the same realm and had to plead guilty and pay $9 billion. And part of that was also that it wasn't just a settlement with the DOJ, but with an alphabet soup of other regulators. And the whole result, I think, left the impression in the corporate bar that what's going on here and how can we prepare?
So one of the things that I've tried to do since I've been in the department is, because I was in private practice before being in the department for a number of years, so I shared some of that perplexed view of how do they get these numbers. So one thing we've been trying to do over the last couple of years is be more transparent and explain, mostly in our resolution documents, how we came to where we came to. Why did this bank pay, and it was actually $8.6 billion, whereas some other earlier bank paid less. And really, the cases are very fact-specific. A company can engage in the exact same conduct and handle it completely differently. Some companies discover a problem, they immediately remedy it, they fix it, they resolve whatever compliance issues they had, they fire the people who caused the problem, they may self-report it to the government, they do a very serious investigation, they fully cooperate. Other companies who engage in the same exact conduct may engage in obstruction of justice, they may not do an investigation, they may affirmatively hide things from the government. So those come to different outcomes. So one thing we've tried to do in our documents resolving corporate cases is to explain why company A got the resolution that it got. So in our deferred prosecution agreements, we'll explain why a company got a deferred prosecution. We'll explain why their deferred prosecution could have been better for them, or could have been worse. Maybe they cooperated, but they took a while to start cooperating. So there are all sorts of different factors that we take into account. And the thing that I think we've changed is we've started explaining those in publicly filed documents, explaining our reasoning. So I really want companies to understand when they have a problem that there is a difference depending on how you handle the issue, there's going to be a difference in the outcome. And we've started to do that. We have a new pilot project in the FCPA area, the Foreign Corrupt Practices Act area, where we are trying to encourage voluntary self-disclosure by companies. And the one way we're doing that is making very clear that there is a delta between companies who self-report and companies who don't self-report. And it's all laid out in paper, and you can read it. And we obviously can't tell you exactly what your outcome is going to be, because I said everything is very fact-specific. But we do recognize the importance of transparency and of not seeming arbitrary, and that's what we're trying to do.
And I think FCPA was one of those examples where it was the most difficult, or for a lot of corporate side lawyers to figure out where the DOJ might go. I know that under your predecessor, some guidance came out which was helpful in explaining in more detail what the Justice Department would consider in terms of FCPA resolutions?
Yes, I think the FCPA, so a lot of companies, we declined a lot of cases in the FCPA space, but there was no public declination. Just this week, we issued 2 public declinations in the FCPA space based on our new FCPA pilot program. So the pilot program, I won't go into all the boring details here, but it essentially provides that if you self-report and you cooperate and you remediate and you disgorge, you may be eligible for a declination. If you don't self-report and then you cooperate, remediate, and disgorge, the chances of you getting declination are virtually non-existent. And it also describes what kind of credit you'll be getting with various degrees of cooperation and self-reporting monetarily, which is frankly at the end of the day what most companies care about. So we're really trying. It's a pilot project. We just started it. It started in April. The first 2 cases were announced this week, and we'll see whether it works or not. We're going to revisit it. Other people in the department will revisit it next year because I'll be gone, but we'll see if it works. And I think it will work, but it remains to be seen.
FCPA is a good transition to the next subject I wanted to discuss, and that is the following. Over the past 15 years, there seems to be a dramatic change in the amount of international activity that the DOJ, that Main Justice is involved in. We've seen it most notably in the LIBOR and FX cases, in addition to FCPA, but I think in a recent speech you noted that you have your own prosecutors or DOJ staffers in 45 different countries. Now, can you tell us a bit, obviously in a more interconnected world, transnational crime is something that's become a much larger portion on your plate, but maybe you could tell us a bit more about the international efforts and some of the challenges you still face there.
So you're right, and I think it is because it is a more interconnected world that we see almost every kind of crime, whether it's major fraud, money laundering, narcotics trafficking, almost every kind of significant crime of the magnitude that we do in the criminal division has some international component to it. It also has some cyber component, which creates other challenges that I won't get into now. But we really have had to work with countries all over the world. The ones you would expect, like countries in the EU, the UK, I don't know if they'll still be in the EU in a couple weeks, but and we work with a lot of countries, but we're also starting to work with countries that you might not expect, like Indonesia, Malaysia, sometimes countries that we don't even have treaties with. We're now doing work with them. And it's very, very challenging because in addition to the diplomatic challenges, which are significant, the cultural challenges, which are significant, we also have a wide variation in our laws, a wide variation in our investigative methodologies. In some countries, the police and the prosecutors never speak to each other, ever. In some countries, individuals essentially have no rights. In some countries, there are surveillance techniques that would not be allowed in the United States or certainly wouldn't be allowed without a court order. In other countries, people can be compelled to talk to law enforcement, which can't happen here in the United States. So sometimes those things have already happened by the time we connect with the other country. And so it's a real challenge not only to work with other countries, but to work with work product that's been generated by other countries in using methods that we ourselves would either not use or could not use. So that's a big challenge. It's also a challenge in the resolution arena. You've got in these big international cases, you've got multiple regulators all over the world and in the United States who want their piece of the pie. So one thing that we've really tried to do is be as fair as we can in resolving cases. Those of you who have been on the other side of us may not think that we're trying to be fair, but we are. We're trying to have there be one pie that's the size that the full pie should be and have that divided up among various stakeholders in a way that makes sense according to the facts of the case. Sometimes it's easier than other times. There are times when it goes very smoothly. We recently did a FCPA resolution where we worked with the Netherlands, and we, the SEC in the Netherlands, agreed and shared in the amount of money that the particular company, which was called Wimpelcom, was going to be paying. There are other times when we can't get people to agree, and that can be very difficult. And I can see how a company faced with something like that would be very frustrated and think that it was being unfairly made to pay double or triple. Frankly, one of our biggest problems in that space, the piling on space, are our state regulators here in the United States. They generally are much more difficult to deal with than foreign regulators are.
Any particular states?
The one we're sitting in right now would be one example, and I've said that to their face, so I can say it to them here. A lot of states. There are quite a few state attorneys general who are very active and have recognized that enforcing white-collar laws is something that gets them.
It's a lucrative practice.
It's lucrative for the state. It also gets them publicity. And it can be a very important thing. I'm not trying to denigrate what they do, but I've seen many times where at the end we think we're at the end of a case and all of a sudden we get a phone call from a state regulator. That can be very frustrating. So it's frustrating for us just like it's frustrating for the companies. But I think we're doing a much better job, not only in dividing up the pie, but also in figuring out where does it make sense for this case to be prosecuted. We've divided up cases with the UK authorities so that folks in the LIBOR case have been prosecuted in both the UK and the US. We're doing that in a number of other cases. We have FCPA cases where people are being prosecuted in Indonesia, Switzerland, Norway, Denmark, and we're not trying to also prosecute those people. So I think as we've developed our international practice and our contacts and frankly developed trust with our international partners, we've gotten a lot better at making those international resolutions make sense.
That's the point you just made about other state regulators noting what kind of success and revenue they can generate through settlements. Am I mistaken? Is that not starting to happen in the FCPA space when you see a country like China suddenly become very serious about corruption, where it didn't seem to be that big an issue 10 years ago? It's almost as though the battle that the DOJ was fighting to bring FCPA to the rest of the world has actually caught on in some parts of it.
I think that the rest of the world is taking corruption much more seriously because a lot of countries have really learned through having corruption in their own countries how corrosive that can be for their economy and how much it undermines trust in government and its institutions and in the law. So we see a lot of countries that previously did not have anti-corruption enforcement. I used Indonesia as an example before. They have a very aggressive anti-corruption authority that brings a lot of cases. And that was a surprise to me. And we see a lot of European countries increasingly interested in anti-corruption. We see China, as you mentioned. And then we see other countries where their interest in anti-corruption kind of depends on who's being corrupt. So a lot of the former Soviet republics don't have robust or even any anti-corruption efforts. And there are some countries where corruption is the coin of the realm and
For the opposition party.
Yes, for the corrupt officials. So we see a wide variation, but there's definitely a trend, as you said, Greg, in the direction of more anti-corruption in more parts of the world.
Now, we have a few minutes left, and we do want to open the floor up to some questions if you have them. So please, if you are interested in asking Leslie a question, raise your hand, wait for a microphone, and then identify yourself before asking the question. Let's see. Well, think about it. One other subject I wanted to bring up, having written about a number of it was precedent setting a few years ago when first one and then several major global banks, either at the parent company level or the subsidiary level, entered guilty pleas before your arrival 2 years ago and then afterwards to various conduct. And obviously this has been a taboo for many years that a bank, a lot of people in this room, I think, used the argument before, U.S. attorneys here and in Washington that if you make us plead guilty, that'll be the end of our business. And I think there was a clear attempt, I think as a residual end of the financial crisis, to force a bank or several banks to plead guilty. And now that that's happened and the safety net was constructed under them, isn't it the case that a guilty plea for a bank has lost some of that draconian element that it used to hold, the fear of God element?
So I have to disagree with the notion that there are a lot of banks that have pled guilty. Since I've been in my job, which has been more than about 2.5 years, there have been 2 in the criminal division. One of them was UBS. UBS had previously entered into a non-prosecution agreement with the criminal division in connection with its LIBOR activity, manipulation of the London interbank offer rate. It breached that agreement by engaging in manipulation of the foreign exchange markets. And there was a provision in its non-prosecution agreement that if it engaged in further criminal activity, it could be breached. And the remedy for the breach would be that it would plead guilty to its prior LIBOR conduct. So that was one. Those are very unique facts. I think that may have been the first time ever that that's happened. The second bank that's pled guilty, and I'm talking about parent level guilty pleas now, the second bank that's pled guilty since I've been here, again, in the criminal division, is BNPP. BNPP engaged in a massive multi-year violation of international sanctions laws involving clearing of transactions for Sudan and Iran. The evidence in the BNPP case was overwhelming that BNPP was very well aware at the highest levels, and in fact had been warned by its compliance department on a number of occasions that was violating US law. These transactions were being cleared through the United States. And
Even against their internal advice?
yes, internal compliance. They sought advice from outside counsel. Hopefully none of you are in the room today, but one lawyer said this violates US law, so they went to another lawyer. It's like, if you don't like mom's answer, go to dad. Dad gave the same answer, and they still went on and continued to violate the sanctions laws. And then when it was brought to their attention, when the investigation started, they didn't cooperate in the investigation. They stonewalled in the investigation, and their conduct essentially permitted the statute of limitations to expire as to individual liability, because BNPP didn't, invoking foreign data privacy laws, didn't turn over documents, which foreign data privacy laws could be a whole nother seminar, which I won't start now, but there are, of course, laws, but we see a lot of invocations of laws that are not correct, and that happened in BNPP. And in fact, we actually got, through the international treaty process, documents from Switzerland and France before we ever got them from BNPP. And for those of you who ever do the international treaty process, you know that that's pretty remarkable. So they had done something really serious, and they didn't address it properly, and they did plead guilty. And we do consider their arguments. One of the factors we consider from any company is whether the collateral consequences of a guilty plea would be so severe that it would
Catastrophic.
Yeah, or that it would undermine, that it would be worse than, that it would make no sense to make a company plead guilty. BNPP, along with every other company that I've ever either defended or prosecuted, made arguments that it would be very serious as collateral consequences. And so we check those with experts. We check them with the Fed. We check them with the SEC. We check them with people who know better than the Department of Justice about bank capital requirements and things like that. So I don't think it's going to be the norm. Neither of those cases were within the normal type of case we see. I think there was a big stigma attached to both of those guilty pleas, and I think there continues to be a big stigma attached to guilty pleas, as there should be.
So we're going to have to hit the 30-second bell on this. A final quick question. We did a story at Bloomberg a few months ago about how the Justice Department, based on one of these settlements with Standard Chartered, was asking for more information about the counsel that was received by the bank from its outside law firms. Should people in this room and in this community be concerned that the DOJ is going to take a closer look at legal advice in general?
So generally, I would say no is the short answer. The slightly longer answer is, if you're relying on an advice of counsel defense for some or all of what you did, we are going to want to know what that advice was. But generally, we have no interest in knowing what a lawyer's advice was, unless there's some exception to the attorney-client privilege, like crime, fraud, which, you know, in our world we see a fair amount of. But I'm assuming no one in this room is involved in that sort of advice to their clients.
At a Bloomberg seminar? Of course not. Of course not. Anyway, Leslie, thank you so much for your time.
Sure. Thank you.